Indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. But to begin by seeking a declaration that there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry, first through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on, that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal.